In a parallel universe far, far away, the emergency declaration in Malaysia has been lifted and Parliament is back in session.
Parliament is now in session. My name is Daphne Hill, and I'm the Speaker of the House. The bill to be discussed today is the Penal Code Amendment Bill 2021. We shall now invite the government to discuss the proposal.
My name is Adrian Chiok.
My name is Tan Ijin.
My name is Ong Eng Hong.
My name is Nimesha Deva, and we are the government speakers for this session.
The current law on rape in Malaysia can be found under Section 375 of the Penal Code. Our current law defines rape as sexual intercourse without consent or against a woman's will, or sexual intercourse with a woman who is unable to consent. Furthermore, statutory rape is committed if a man has sexual intercourse with a girl below 16 years old, and in such cases, her consent is totally irrelevant pursuant to Section 375, subsection G. Currently, the existing law on rape is unsatisfactory from multiple angles. As such, we have proposed amendments to the current Section 375 of the Penal Code in the following areas. Firstly, what type of penetration amounts to rape? Sexual penetration, including penile and non-penile penetration, as well as vaginal and non-vaginal penetration. Secondly, who can be raped? The gender neutralization of Section 375. Thirdly, the law of marital rape. And lastly, the need for menstrual.
To contextualize the discussion regarding reforms of the law of rape in Malaysia, we must first consider the historical purpose of rape legislation and how it has evolved. In the past, rape legislation was founded on ancient male concepts of protection of property. The criminal act of rape was a trespass against his right to control vaginal access of all women who belonged to him. For example, virgin daughters were a valuable commodity belonging to their fathers, while wives were seen as chattel of their husbands. Therefore, the primary purpose of punishing rape was to financially compensate the man who owned the victim. However, in modern times, as humanity has progressed, rape is now punished for being a crime against the person. With that key concept in mind, let us now take a look at the current law of rape in Malaysia. Malaysia differentiates between different types of sexual penetration, only classifying the non-consensual penetration of a woman's vagina by a penis as rape. If, however, a person's mouth or anus is non-consensually penetrated, this would not be considered rape under the Penal Code, but rather carnal intercourse against the order of nature without consent under Section 377C. Additionally, if a person is non-consensually penetrated by an object, this again is not rape under the Penal Code, but rather sexual connection by an object under Section 377CA. To illustrate the harms of this separation, we will look to the unsatisfactory results yielded in case law. In the case of Buhari bin Ahmed against public prosecutor, the accused was convicted for a charge of outraging the modesty of a 7-year-old girl by inserting a finger into the vagina of the little girl. In Bunya Anak Jalong against public prosecutor, the Court of Appeal acquitted a 60-year-old man for the offence of rape. Despite impregnating the victim, he was acquitted because the prosecutor had failed to prove beyond reasonable doubt that the penetration of the vagina was done by the penis instead of fingers. Despite there being a clear, non-consensual penetration of the vagina in both these cases, it was not considered to be rape because the only type of penetration that can amount to rape under Section 375 of the Penal Code is penile penetration, a reform recognizing any non-consensual penetration of the anus, mouth, or vagina by a penis, other body parts, or object as rape is necessary. Groth and Burgess describe rape as a pseudo-sexual violent act, addressing issues of anger, control, and domination more than desire. Additionally, rape is an attack to a person's autonomy over their own body. Regardless of what penetration occurs or where, the nature of these repugnant acts are conceptually and qualitatively the same and need to be equated to rape. The side effects of penetration in all these situations are the same: physical, psychological, and emotional trauma. This outdated law delegitimizes what the victims feel to be rape and a violation of their body. There is also little distinction in the penalties for non-consensual versus consensual acts of carnal intercourse against the order of nature. In fact, the only difference is that the non-consensual act imposes a minimum jail sentence of 5 years. This suggests that the legislators' motivation for doing so was their interest in codifying their idea of abnormal or morally wrong sex, as opposed to criminalizing all non-consensual sexual penetration. Jurisdictions such as South Australia, Thailand, and the US, amongst many others, have extended the definition of rape given our new understanding of the Act. The Awam Anti-Rape Task Force even recommended redefining the term sexual intercourse to extend beyond just acts of penile penetration to include anal and oral penetration. As such, the proposed amendment is to subsume Section 377C and Section 377CA into the law of rape under Section 375 of the Penal Code.
Under our proposed amendment to Section 375 of the Penal Code, we propose for the gender neutralization of the offence of rape. The gender-specific terms man and woman will be replaced with a gender-neutral term person. Our justification for this is that there should not be any form of gender discrimination within the law of rape in Malaysia. It is submitted that this will be in line with Article 8 of the Malaysian Federal Constitution, which provides for equality and equal protection of the law regardless of gender. Muhammad Ismail in his article stated that the law of rape should focus on whether the crime itself has been committed and not whether the victim was a man or a woman. He also further went on to say that the law of rape should concern itself with protecting the modesty and dignity of all persons. We wholly praise and accept this view. As mentioned earlier by my groupmate Nimisha, rape is a violation of bodily autonomy and it is a heinous crime against the person. Hence, rape legislation in Malaysia should seek to protect all victims of rape regardless of their gender and or sexuality. In relation to this, it is understood that carnal intercourse against the order of nature is prohibited under the current law. However, the issue to consider with these acts is the lack of consent, not whether the act itself is morally wrong or frowned upon. Therefore, it is submitted that if a person has unnatural sex with another without their consent, it should fall within the ambit of rape. Hence, it is imperative to subsume the current Section 377C of the Penal Code under Section 375 in order to educate the public that consent is of utmost importance when engaging in any form of sexual activity. It should be further noted that in doing so, we are not legalizing or encouraging consensual unnatural sex. Rather, we are merely putting emphasis on the severity of the offence of non-consensual sexual penetration. In subsuming Section 377C into Section 375, we will not be creating laws which do not align with the other offences within the Penal Code on unnatural sex. We are merely equating those non-consensual acts to rape. Having said that, it is therefore submitted that the gender-specific terms under the current Section 375 must be replaced with a gender-neutral term. In addition to gender-neutralizing the offence, our proposed amendment also includes an interpretation provision which recognizes surgically constructed genitalia. This provision is inspired by the legislation found in other jurisdictions, namely Section 79 of Subsection 3 of the UK Sexual Offences Act and Section 2 of the New Zealand Crimes Act 1961. The main purpose for including this provision is to ensure that the offence of rape is inclusive and not merely applicable to a specific group of people. Another reason for including this is due to the growing transgender community in Malaysia. According to an online news article by Malaysia Kini, a government-funded study in 1997 found that there were over 20,000 transsexuals in the country. These numbers would have increased since then. Therefore, it would be necessary to include this interpretation provision to recognize that persons with surgically constructed and functioning genitalia are capable of raping and being raped. Now, to summarize, sexual penetration under our proposed amendment to Section 375 is defined as the penetration of the victim's vagina, mouth or anus, however slight, by any part of the offender's body or by any object, except in the course of a procedure carried out for a valid medical treatment or is authorized by the law. By replacing the term sexual intercourse with sexual penetration, we will then be codifying decisions from case law such as Sidet bin Dudan, Chong Yo Hoi, and Razi bin Amin. These cases respectively held that the slightest penetration will suffice and ejaculation need not be shown in proving rape. It is submitted that this would be a step forward for Malaysia, since the law of rape in other jurisdictions such as the UK, Singapore, and India use the term penetration or penetrate in their legislation instead of sexual intercourse.
Marital rape is unconsented sexual intercourse between married partners, recognized by the Convention on the Elimination of All Forms of Discrimination Against Women (CEDAW) Committee as a form of violence against women. Despite being a state party to the convention and urges from the committee to criminalize marital rape, it remains to be exempted from criminal charges in Malaysia. Historically colonized by the British, our immunity for marital rape was adopted from the UK. In 1736, Sir Matthew Hale, the Chief Justice of England, infamously commented that the husband cannot be guilty of rape committed by himself upon his lawful wife because she has given her irrevocable matrimonial consent. Fortunately, this was overruled by the House of Lords in R against R in 1991, stating that marital rights exemption is nothing more than common law fiction. In Malaysia, the Women's Aid Organization reported that at least 100,000 women will be raped by their partners during their lifetime. Yet, marital rape is explicitly stipulated in the exception to Section 375 of the Penal Code. Marital rape is only recognized if the woman has been living separately from her husband or has obtained injunction to restrain her husband from having sexual intercourse with her. These two conditions have been criticized because it places the responsibility on the woman to protect herself. If the wife fails to do so, it is her fault, thereby encouraging victim-blaming culture. For decades, women's rights groups advocated for a reform in this area of law. Their calls to action were met halfway in 2006 with the addition of Section 375A to the Penal Code, making it a criminal offense for husbands to cause hurt in order to have sexual intercourse. The CEDAW committee praised this addition, stating that it strengthens legal protection for wives in Malaysia. However, it is submitted that this addition to the law fails to serve the section of the community it set out to protect. Section 375A looks past the significance of consent for sexual intercourse between married partners, instead placing the emphasis on hurt or fear of hurt or death. Unconsented sexual intercourse is rape, and rape can happen regardless whether there was hurt or fear of hurt caused by the husband. Marital rape immunity stems from patriarchal hierarchy of power in families and society at large, denying women of their bodily autonomy. The change in law is most welcome and necessary as it otherwise continues to perpetuate harmful gender norms and expectations. Women are no less inferior than men and are certainly not chattels of the husband. One's consent to marriage is not perpetual consent to sexual intercourse. Notably, there are views that the recognition of marital rape in Malaysia is difficult. This is because it conflicts with Islamic principles, which propounds that a husband has the right to be intimate with the wife, and the wife must obey, unless it falls within limited exceptions. Despite that, academics commented that these are patriarchal interpretations of ambiguous religious texts. In fact, it is pointed out that the doctrine of Mushara bil Maruf, which advocates for respecting the needs and willingness of the wife, is applicable in sexual matters. Thus, the recognition of marital rape can be reconciled with religious views. Furthermore, the federal court has established that Malaysia exists as a secular state. Hence, religion should not be a consideration in the drafting of a federal offence. In Singapore, the amendment to abolish the marital rape immunity was passed in 2019. India is also moving towards a similar direction. The Supreme Court criminalized non-consensual sexual intercourse with a wife between 15 to 18 years of age. It is admitted that the current position of the law in Malaysia is unsatisfactory, and the removal of Section 375A and the exception under Section 375 are necessary to protect married women from unconsented sexual intercourse.
The Latin maxim of actus non facit reum, nisi mens sit rea, is well known among the legal scholars and practitioners of criminal law. It essentially means that an act does not make a man guilty of a crime unless his mind is also guilty. However, Section 375 of the Penal Code is silent on the element of mens rea for the offence of rape. The only parts that make reference to the perpetrator's state of mind are paragraph C and paragraph D. Paragraph C provides that the man must have known or has a reason to believe that the woman's consent was given in fear of hurt or death. Whereas paragraph D provides that the man knows that he is not the woman's husband. Nevertheless, these elements of mens rea are situation specific and are not universally applicable to all situations of rape. In the absence of the element of mens rea, Sankaran opined that the actus reus of the perpetrator is sufficient to prove the presence of a guilty mind for the offence of rape. Basically, the prosecutor only needs to prove that the perpetrator had sexual intercourse with the victim without her consent. It is then presumed that the perpetrator had the intention to commit rape since he proceeded to commit the act in the absence of the victim's consent. Nevertheless, the perpetrator has an opportunity to raise a general defense under Section 79 of the Penal Code, which does concern the perpetrator's state of mind. This is illustrated in the case of public prosecutor against Teo Eng Chan, whereby a 16-year-old girl was raped by 4 men. The court held that an honest belief of consent is not a good defense pursuant to Section 79 read together with Section 52 of the Penal Code. To invoke the defense under Section 79, the perpetrator must have had sexual intercourse with the victim, believing with due care and attention that she had consented to the act. However, as stated in Section 105 of the Evidence Act 1950, the burden of proof is on the perpetrator himself to raise such a defense. As such, Section 79 of the Penal Code is technically not the mens rea for the offence of rape, because according to Justice Ong in the case of Adnan bin Khamis against public prosecutor, mens rea of an offence should be proven beyond reasonable doubt by the prosecutor and not the accused. Therefore, it is submitted that the current law of rape should be amended to explicitly spell out the element of mens rea. It is imperative to note that the consequence of violating criminal law is distinct from breaking ordinary civil law. The punishment imposed by criminal law indicates that the perpetrator's action is subject to condemnation. Hence, mens rea plays a role in determining whether the perpetrator has a culpable mind that makes him deserve criminal blame. Although there is a need for the element of mens rea for the offence of rape, it is submitted that its standard should not be too great to the extent that it becomes a restraining factor for the prosecution. This is due to the unique nature of the offense of rape. As discussed by my groupmate Nimisha earlier, rape is essentially an attack against a person's autonomy over his or her body. Hence, what truly matters is whether there is consent from the victim. The context of sexual penetration is so intimate that everyone will be expected to have notice of whether the other person is consenting to the act or not. A failure to observe this would be culpable on its own. Therefore, the appropriate mens rea for rape would be that the perpetrator intentionally commits sexual penetration with the victim and he does not reasonably believe in good faith that the victim consents. Such a standard indicates the need for everyone to exercise due care to ascertain the existence of consent prior to engaging sexual activity. This aligns with the object of criminal law on rape, which puts emphasis on the importance to respect others' autonomy by always seeking consent.
In addition to these main changes, we also propose some supplementary changes to bring the new provision into sync with the remaining provisions in the Penal Code. Firstly, we have removed the 7 subsections from A to G and replaced those provisions with a definition of consent. This situation will still be referenced under the new definition of consent, except paragraph A, against her will. This phrase is unsatisfactory because the victim will have to resist in order to fulfill the requirement of against her will according to State of UP against chattel law. This is further mentioned by Cashinathan and Omar, where the burden is usually placed on the victim to show evidence of physical violence that could be considered as an act against her will. Thus, we submit that the victim's consent is relevant and not the victim's will. Secondly, we're amending section 376, subsection 2, subsection D to with or without her consent when she is under 16 years of age. Section 376, subsection 2, subsection E will also be removed so that the statutory rape is consistent with the age of under 16 years. This is because the law shouldn't impliedly suggest that raping teenagers is less serious than raping children by separating the two into separate aggravating factors. The seriousness of the crime should be equal because teenagers, especially between 12 to 16, were usually raped based on the statistics from Women's Aid Organization. Lastly, the current section 377C and section 377CA will be removed because both these offences have been covered under our proposed amendment to section 375. The problems with the current section 375 can be seen in Bunya Anak Jalam against public prosecutor and Bohari bin Amit against public prosecutor, where the accused had inserted their fingers instead of penis into the girl's vagina. However, the court had acquitted the accused in Bunya and held a light sentence of outraging modesty under section 354 as compared to a more serious offence of rape with heavier punishments in Bohari. If the amended section 375 applies, the problem will be resolved and they will be charged for rape as the penetration includes any part of the body of a person. Moreover, they will be charged for statutory rape as the victims were 15 and 7 years old girls. The current law on rape in Malaysia, which is completely out of date, is in dire need of reforms. The reforms suggested will create a law that is far better equipped to protect the victims and uphold justice. In summary, the main reforms are to broaden the types of sexual penetration, remove the gender-specific terms, remove the marital rape exemption, and include the need for measure of the offence of rape. We shall now proceed with the voting session. Those in favour, please say aye.
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 Those not in favour, we don't care. The bill has been approved.